What's up? My name is Ken Dumbo, the MC with the sauce. Don't forget to subscribe to J. Cool.
Thank you, my lord. The court knows that we ask for leave to appeal on the basis of reasonable prospects and alternatively on the basis that the matter is of sufficient public importance that a judgment by the Supreme Court of Appeal is warranted. The court also knows the latest authorities on this point, that on that second leg of the test, which is the judgment of Southern African Litigation Center, what really the SCA says there is that it doesn't matter what the view of the court is on reasonable prospects. If the case is sufficiently important, it may grant leave to appeal on that basis alone, even if it believes that the prospects are not good. But this case stands on a different footing. We say that the prospects are strong. In relation to prospects, there are really two issues I want to argue. The first one is on the question of the choice of law and where that takes us. And then the second is the application of the South African Constitution to the dispute and whether it should have been applied, and if it had been applied, what the outcome could have been. So on the question of lex loci, which is the choice of law dispute, now it seems that if we are correct in the way we understand the judgment, that the judgment separates between burial rights and the contract. On the burial rights, it applies the Kaunda judgment. And then on the contract, it applies Endumeni, which is a South African authority. So it seems that the contract itself was decided according to South African law. And then the burial rights, it's unclear whether the court regarded the burial rights as a species of contract or as a species of public law. But on burial rights, Kaunda applies, and then on contract, Endumeni applies. And that already gives us a difficulty because we have two systems of law in the same judgment that are applicable. And when you actually look at our learned friends' heads of argument that we find this morning, they also seem to understand the judgment in the same way that we do. Because what they say in relation to the contract is that the judgment itself says our law applies. And you will see that in the heads of argument, paragraph 24. And then you will see there is a reference specifically to Endumeni on the under paragraph, I want to see paragraph 16. So it seems both parties understand the judgment similarly, that burial rights is Zambian law, the contract is South African law. Let me start then with the contract, what South African law is on contract, because that's what we try to spend a little bit of time exposing in our written argument. Now, when it comes to a corpse, a dead body in South Africa, the law follows the Roman Dutch system. In fact, when we research this, it comes all the way from the Roman law. It's affirmed by Foot as well as Hugo de Groot in their exposition of the law. They both say that a corpse is outside the realm of contract. No one can contract about a corpse. A contract over a corpse is ipso facto contra bonus mores, something that cannot be contracted upon. Foot, as well as Hugo de Groot, have been affirmed in several judgments that we have traced. So if I could take the court to our judgments, our heads of argument, we deal with this from paragraph 32 of the heads of argument. That's why we say that our common law, which is now given effect to by the Constitution, The position was that Roman Dutch law proscribed the contract over a corpse because the human body and its part were classified as res extra commercium, things outside the sphere, the commercial sphere, in this case the contractual sphere. A corpse was not regarded as a thing that could be owned and thus capable of being transacted over by contracting parties. Indeed, according to Professor Price, and that's the article that was published in the South African Law Journal, which we've attached there, it's called Legal Rights and Duties in Regard to Dead Bodies, Postmortems and Dissections. The deceased executor and or their spouse and heirs had a restricted legal right of possession, which conferred on them the right to bury the body in accordance with the wishes of the deceased. Now that, yes, in the absence of the will, you will then see what happens when there is no will. When there is no will, the judgments then start from paragraph 33.1. Sage versus Scutts, 1971, it's a Transvaal decision, where the portion we've cited says matters affecting the disposal of a corpse are rarely subject to litigation, with the result that there is very little modern guidance on the subject as a whole. But applying general legal principles, it would seem reasonably clear that the primary duty of the executor, or failing him, the surviving spouse, child, parent, or other near relative, is to dispose of them in accordance with the terms of the will, provided that this is not impossible, too expensive for the executor to bear, or unlawful. It has been stated that in English law, the executor is not bound to obey. Even if this proposition is correct for English law, it does not follow that it is correct for Roman Dutch law. Crotius, that's the other name for Hugo de Groot, specifically says that a will, besides disposing of the deceased property, may and directions as to his burial. It is taken for granted that the heir must carry out the terms of the will as far as possible. It therefore follows that in our law, directions in the will as to the disposal of the body must, if possible, and what then happens when there is no will? Firstly, if you have a will, it must be followed if possible. We deal with this then at 33.2. The court in Said also cited Foot, and that's another Roman Dutch law of burial. Each in their order of succession. So, and then that authority is then followed in paragraph 33.3. So no one has been appointed to dispose of the human remains. Funeral rights. The duty falls to the heirs nominated by the will. If no heir is nominated, the legitimate or cognate heirs who succeeded must do so. Failing this, the duty of burying the deceased falls on the civil authorities at the expense of the estate. And then again, Tsaula, which is a case that comes after human, where it says it is quite clear that it is the duty and therefore the right of the heir to bury the deceased and to use his discretion in doing so where no testamentary directions have been given. That's Tsaula, it's a 1976 judgment. And then a year later, Mbanjo versus Mona, again, 1977. Then 1984, Kumalo versus Kumalo, Sekeleni, 1986, Falaba, 1990. Then it runs all the way. And basically, the law is this. You don't contract over human remains. A corpse is dead, it's not a property. It cannot be contracted upon. What you do, you follow the law of succession. If there is a will, you follow the will. If there is no will, the law of interstate succession applies. So if you are dead and you are a husband, your remaining wife takes the decision. If the wife is also deceased or incapable of taking the decision, the children take the decision. If the children are incapable, your parents take the decision. If the parents are incapable, your siblings take the decision. But
if the wife and the children cannot agree,
yes, those are.
The deceased
Yes, the wife then takes the decision because it's the first, it's the heir. So the executor will generally follow the will, but the heir will then make a decision because that's the surviving spouse.
In case of interstate succession, the wife, the interstate heir, and the children.
Yes.
Also, depending on the value of the estate.
Yes.
And now, the wife, you may find that it's a case where the husband is single and
Yes.
Yes. And also your submission that they cannot negotiate about the value.
No, they obviously can negotiate and reach a consensus, but that means they have reached a consensus on what should happen. What is prohibited is contracting over a corpse. But obviously a family can make a decision about what to do with the corpse. But the rules of that are succession rules, either by will or intestate, but they are succession rules. Now that's what happens when between the stage of death and burial, when the corpse is just lying in a morgue. So that's the South African law. Now we come back then to this question that we are faced with here. I don't have to persuade your lordships and my lady that you were wrong. That's not my duty today. That will be dealt with at the Supreme Court of Appeal. I simply have to persuade your lordships and my lady that there is at least a reasonable prospect that this case can be decided differently. So if you were then to apply the South African law on the contract part of the case, what would have been the correct outcome? The correct outcome would have been an unqualified right on the heirs of the deceased to make a decision about what to do with the remains of Mr. Lungu. Unfortunately, the judgment does not recognize that fundamental premise of South African law, which we say we will be capable of showing the Supreme Court of Appeal that there's a long list of authorities on this point, and the long list of authorities is against the Zambian government. There's a secondary aspect to the South African part of the case. I've just been dealing with the common law, which is this: South Africa would have proceeded from its own constitution as a starting point. And Ms. Esther Lungu did in fact plead constitutional rights. We've cited two authorities. The one is the authority of Mohammed. What happens to a foreigner who's in South African soil and comes to a South African court? Because that's where Ms. Lungu is. The case of Mohammed is very, very crucial because you have a Tanzanian who is suspected of committing terrorist activities in Dar es Salaam, bombing the US embassy, flees to South Africa, gets caught in South Africa. Is he entitled to the protections of the South African Constitution? And he's not caught in South Africa, he's been sent to America. So that's the problem. He's foreign, he's bombing something there, he's here. He's wanted in America. The question came then in 2001 before the Constitutional Court. Well, is Mr. Mohammed entitled to the protections of the South African Constitution? The Constitutional Court said for as long as he is in South Africa, in our jurisdiction, he's entitled to use our Constitution to protect his rights and interests. Another case is COSA, which we've also referred to. Foreigners come to South Africa. Then they say, no, we don't have access to socio-economic entitlements or privileges under Section 27. We also want to apply for those benefits. And then the government says, no. If you are a foreigner, you are not entitled to the South African protections. Now, Justice Mohoro deals with this and then says, Section 7, subsection 1 of the Constitution applies to everyone who is in the territory of South Africa. So the only qualification to obtain our protection is being in the territory of South Africa. Now we apply that to this case. Again, I don't have to show that you were wrong. That's not my duty today. But we just apply that to this case. Ms. Lungu is in South Africa. She is suing in a South African court. She's relying on the South African Constitution for protections. That has two consequences. The first one is the right to dignity, and then the second is the right to family integrity that are provided for in the South African Bill of Rights. And she's entitled to assert those in order to assert autonomy over the body of her husband. This is her husband who's died. She says, well, I want to dispose of this body as I wish. What you cannot have a foreign state coming to our courts demanding the application of a foreign law in order to deny someone who is in our jurisdiction the rights that are protected by our Constitution. That substantially weakens the protections that are in our Constitution. So that's the second feature of applying South African law, is that inadvertently, I'm not saying this is deliberate, inadvertently you end up depriving someone who is in our territory of the protections of our Constitution. And those protections of our Constitution apply in relation to our state, our own state. Now, how much more in relation to a foreign state? So that's the second aspect that we say we would like this matter to go to the Supreme Court of Appeal. And then there is a judgment.
You agree that the person in South Africa can into an agreement before the state? I think this is the gist of this man. It is true. The government says that the an agreement before the state.
Yes.
If there was no agreement at all,
yes.
I think I follow your submission. This judgment says that they did engage negotiations and reach an agreement.
No, I agree that the fact that you are a foreigner in South Africa does not deprive you of the right to enter into an agreement with a foreign state. But I'm saying that what is supreme in that equation is the South African Constitution. That you still retain your entitlements as a foreigner if you are within the Republic to rely on the South African Constitution to protect you.
I agree with you.
Yes. Now, the problem, again, this was an issue that was disputed on the papers, right, about what is the status of FAA 7 versus FAA 9. That was disputed. But the point I'm making is that that contract must itself be consistent with South African law. You cannot enter into an agreement that is inconsistent with South African law. You have to enter into a contract that is recognized in South African law. And you can't have a foreign state that demands the application of foreign law in a South African court, because that denudes the South African Constitution of its autonomy within its territory. And Zambian law, there was nothing here that suggested that Zambian law is extraterritorial in its application. Zambian law is not extraterritorial. It applies in Zambia, not here. This point, this is now the third part, I'm going to close the discussion on the contract, is dealt with in the judgment of East Asian Consortium versus MTN. This question about Lex Loki. It's reported recently in 2025, volume 5, SA 33. And there are two judgments that are delivered. There's a judgment by Justice Unterhalter for the majority and Justice Molemela for the minority. Justice Unterhalter, between paragraphs 99 and 110, deals with the rules of resolving a Lex Loci problem. In that case, it is a delete. So what the issue in that case is that MTN is accused of bribing Iranian generals in order to secure a contract in Iran. That they must pay damages to a certain company that lost out on the bid because of the bribery. The question then that arises is which law should apply, Iranian law or South African law? And Justice Unterhalter, and he says it's the court that has the closest connection to the suit. And then Justice Molemela are themselves subject to the South African Constitution because it's supreme in relation to our territory. It's supreme. So even where you've got a lex loci dispute, where you say Zambia, it's still subservient to the South African Constitution if the dispute is being litigated in our territory. So even then, if you applied those because it's a contractual case. What is the law that has the closest connection to the suit? What do I have? You have a South African, you have a person in South Africa, and a body in South Africa, and a contract in South Africa. All of those three elements. The contract is contractual. It's a contractual case. What is the law that has the closest connection to the suit? What do I have? You have a South African, you have a person in South Africa, and a body in South Africa, and a contract in South Africa. All of those three elements. The contract is concluded here. The max, in other words, the subject of the contract, and I'm using the word max advisedly because my own submission is that a body is not a max. A dead body, a corpse is not a max. And then you have the party, one of the parties in South Africa as well, concluding that contract. Now you then have to ask yourself, what is the jurisdiction that has the closest connection to that suit? Then it becomes South Africa. And the law in South Africa is clear. There is an autonomous right on the part of the widow to decide what to do with the bones of their husband. Now, we said these things are controversial in our law. They are also emotive, but they are also unsettled legal principles. The MTN case shows us that they are unsettled. MTN is now before the Constitutional Court. Leave to appeal was applied for. But the issue has still not been settled about how to resolve a lex loci dispute in the sphere of contract. And what is the role of the Constitution in a lex loci dispute? It is not correct that the lower courts should have a final say on the matter. What is correct is that disputes like this must be finalized by the Supreme Court of Appeal. We were hoping that we could split this thing up and get to the Constitutional Court sooner. We've been told we must start here. That's fine, we accept that. But the question of principle remains. This is a complex legal question. It has not been resolved before. It's the first case we are aware of where a foreign state comes here to claim the bones of a deceased person contrary to the wishes of the wife. It's the first case that we are aware of.
On the time allocated, I'll give you another 5 minutes.
I started at 10:53.
Okay, yeah. So I'll give you another 5 minutes to
Yes. Yes, so that's why we say this is a matter that should go to the Supreme Court of Appeal. Now,
sorry, is your basis the lex loci contracting? Because you say it's not a contract. You can't conclude a contract on a body.
yes, that's what I say as the first basis. And then I'm saying on the alternative, if that submission is...
It's alternative.
Yes, if that submission is incorrect, I'm asking the courts to follow MTN and ECL. But you don't have to follow them. You simply have to say that they show that the issue is a contentious issue, which must be resolved by the Supreme Court of Appeal. Then we come to the question of the burial rights. How is that issue to be decided? There are two problems that I want to point out. The first one is that you have this tension between the lex loci and the burial rights. Both of them could give you different outcomes. Because it's possible for you to say, If I were in Zambia, the state interest would trump the interest of the wife. But if I'm in South Africa, there is no way that the state interest would ever trump. But if I'm applying the lex loci contractus, then South African law applies, and therefore it's easy to resolve the dispute. So even that issue about what Zambian law is still comes back to the first issue of the lex loci. So the lex loci is the key to resolving the dispute, and the lex loci is a complicated question of law that it requires. Now, if that's wrong, what I have submitted to the court, if that's wrong, you still have the residual problem, which is, what is the Zambian law on this issue? And there are two related questions. Question number one is, how do you prove the law of a foreign state? And South African authorities are clear. The law of a foreign state is a question of fact, it's not a question of law. And therefore it's proven by evidence. And whether you had enough evidence here or not is a debatable question. But what's clear is that we didn't have an affidavit from an expert proving what the Zambian law is. And what that law ultimately revolves around is one judgment, Kaunda. And what is notable about Kaunda is that it never resolves the question of what the law is in Zambia over the human remains. When we did our own research, what we found is that Zambia is one of these unique jurisdictions. At some point, they did follow the Roman Dutch system when they were part of the Rhodesia. And then at some point, they did follow the English system. But we looked at Blackstone, who is the main authority of the English common law, and we looked at Foote and Hugo de Groot, the main authorities in Roman Dutch. Both of them actually agree on the status of the human body, that it's outside of contract, but if it is to be contracted upon, the decision is that of the heirs. So even if Zambia's common law is the English law system, we come to the same conclusion. But Zambia also is unique because Zambia has a fundamental rights constitution. Section 1, subsection 1 says the Zambian constitution is supreme. And it contains the same protections that the South African constitution contains. Privacy, dignity, equality. And those would have been rights that Mrs. Lungu would have been entitled to enjoy, even if she was in Zambia. And then you have the third problem, which is the Kaunda decision is a unique decision and distinguishable on the fact. Kaunda died whilst the benefits were extant. Mr. Lungu died whilst the benefits had been removed. You cannot reinstate benefits on a corpse. The legal position is preserved as at the time of death. The legal position as at the time of death is that Mr. Lungu had lost his presidential benefits. So those could not be...
What about his right to be buried? Had he lost that? He is not able to have passed on.
No, he lost the benefits that came with being the president of the country.
The protection, the office staff?
Yes, all of those.
But the right to be buried and every attendant benefit that flows from passing on as a former head of state?
No, he has a right to be buried, but the corpse doesn't have any rights. The wife has a right to bury the deceased, but the wife has made that decision. The widow has made that decision. What you cannot have, and this is the oddity of the argument by the Zambian government, if the rights and benefits, because a corpse has no rights. So you cannot say a corpse has a right to be buried. A corpse has no right. A corpse is not a legal thing. So if the benefits are removed, those benefits are removed on a living thing, on a living organ. Once life ends, the rights also end. So what they have now tried to do is a very artificial thing, which is to reinstate rights on a corpse.
No, those benefits would be for the wife, not on the corpse.
Precisely.
That's why they say under oath that those benefits would continue.
Those would be benefits. Yes, those would be benefits of the office that was held by Mr. Lungu. But at the moment, those would be benefits extended to the widow. Exactly. Justice Lidwaba, you're absolutely correct. Now, if it is a benefit, no one is compelled to accept the benefit. No one can be compelled to accept the benefit. It imposes no obligations on her at all.
Yes, but did the Kwanda judgment say it's just because of the benefits?
No, it did say that it's because of the status
Yes.
of the former president.
And his status remains that of a former president.
Well, yes, the problem remains that the benefits attaching to that status were removed. And one of the benefits is getting your burial paid for by the state, which confers on the wife. And that is the critical problem. And the fundamental problem, though, with Kaunda is that it does not say that this is the law in Zambia. And it never engages with the rights of a widow. When the widow says, this is what I want to do with the bones of my husband. It never engages with that. And then it makes
this judgment, the way I understand it, is not saying the Zambian government should impose the Kaunda judgment when the corpse is in Zambia.
This judgment here?
Yes.
No, I would say this judgment is even more invasive because the corpse is here. It says the corpse must be repatriated.
Based on the agreement.
Oh, yes. No, I agree. If the true ratio is the agreement, then I don't have to advance what I'm advancing because I've said enough about the agreement.
Okay, thank you.
Mr. Last question from me. I hear you say, and I understand what you say, unique set of facts should go to the SCA. But it's so fact specific. Will it ever be a ratio for another decision?
Yes, we would submit that the question as to a foreign state
And a foreign ex-president.
Yes, it's so unique. It's really a unique case. But it cuts both ways. It's the uniqueness of the case that requires the authoritative statement of the Court of Appeal because of the consequences that it has for our Constitution.
But as I say, it's so fact-specific. Will it really be a president for something else?
Who knows? Who knows? We don't know, but I think that the uniqueness of these facts shows that it's actually something that Mohammed, for instance, we always thought was an extreme case. But in 2012, we had another judgment in Botswana on similar facts. And no one could have thought that the Mohammed judgment would be used again. Since the Botswana case, we haven't used Mohammed again. But there's something unsettling, Justice Kotaren.
Thanks for tuning in to JQ News. Don't forget to like, share, and subscribe for the latest updates on tech, politics, and everything in between. Until next time, stay cool.